All right, we're going to talk about foundation right now. Foundation is always relevant, and it's encapsulated legally in Rule 104 at the beginning of the Rules of Evidence. I'm just going to read exactly what it says and talk about each section individually. Rule 104, Preliminary Questions. A. The court must decide any preliminary question about whether a witness is qualified, a privilege exists, or evidence is admissible. In so deciding, the court is not bound by evidence rules except those on privilege. When we talk about privilege, we mean like attorney-client privilege, doctor-patient confidentiality, spousal privilege. There's a couple legal privileges that require a certain relationship between two individuals. In those cases, when establishing those relationships, that sort of foundation is subject to the rules of evidence, but all other types of foundation, qualification, how they came to know the case, are not subject to the rules of evidence. Particularly in most applications, they aren't subject to relevance rules. So foundation is a relevant exception to relevance. So even if where someone's from might not be relevant to proving or disproving something in the case, it is relevant to showing how this person came into contact with the case, how this person is at all related to the case. All you need to get out of 104A is that foundation is a relevant exception to relevance. If someone says, objection, Your Honor, relevance, you can say, Your Honor, I'm just laying foundation, and almost always that will get you through. Do not object to foundational questions at the beginning of directs as relevance. It would take very, very, very extraordinary leaps of faith made by the other side's characters, usually, and going very deep and ham on what their backstory is to ever try and get out an objection from me. I've never made this objection. I've heard it made. It very, very rarely goes over well. Also, as an aside, Rule 104 isn't the type of rule that you want to cite. It's good to know because it underlies key parts of the rules of evidence going forward, but it's a rule that very rarely is cited. The portion that is cited, if ever, is 104B, relevance that depends on a fact, also called relevancy conditioned on fact. Namely that another fact is the condition for the relevance of the testimony you're eliciting. We'll read and get a better sense of it. When the relevance of evidence depends on whether a fact exists, proof must be introduced sufficient to support a finding that the fact does exist. The court may admit the proposed evidence on the condition that the proof be introduced later. I have an example if that was a little hard to follow. Last year, there was a robbery that occurred with a knife. And the color of the knife was known to a couple of different individuals in the case. Asking Haley Floyd, the victim of the robbery, what color was the knife, isn't inherently relevant, and hopefully that's pretty obvious why it isn't. The color of the knife, whether it's black or blue, doesn't make anything more or less likely in the case, either a material fact or an element of the charge. But this is a perfect example of relevancy conditioned on fact because the color of the knife, while not relevant on its own, can be relevant if the alleged defendant, Whit Bowman, owns a blue knife. So if Haley Floyd says the color of the knife was blue, and later on in the case we elicit testimony that Whit Bowman owned a blue knife, it makes it more likely that the knife used against Haley Floyd belonged to Whit Bowman. So the relevancy of the fact that the knife is blue isn't clear at first. If you do get an objection to relevance, you can even cite 104 and say, Your Honor, we're going to lay further foundation that Whit Bowman owned a blue knife. So whether this witness did or did not see a blue knife while she was being robbed makes it more or less likely that Whit Bowman was somehow involved. So that's an example of relevancy conditioned on fact, and the rare instance when you may want to cite 104B. Even then, I wouldn't really recommend it because you can just make a logical argument, and that should be fine. You could just say, well, we're going to bring out this testimony later and kind of get the same thing across without directing them to the rule. But it's there for your knowledge. Lastly, 104E, evidence relevant to weight and credibility. Parties right. When it says this rule, it means Rule 104 about preliminary questions. This rule does not limit a party's right to introduce before the jury evidence that is relevant to the weight or credibility of other evidence. So evidence that that Officer Williams, in this case, in the Park v. Duran case, hasn't completed his detective certification. So he is not a certified criminal homicide investigator. Isn't relevant, but it casts doubt on Officer Williams' testimony and on the investigation that he performed because it attacks his credentials. Essentially, what this is saying is that bias and credibility is always at issue, and it is a valid and commonly used, and please do use it, exception to relevance. So, and not exception, it's just it isn't irrelevant. It is in fact relevant. If anything you're trying to say goes to the bias or credibility of the witness, or of any witness who's material in the trial, then it is relevant. And 104E is just saying that the foundational questions do not absolve the relevancy of bias and credibility attacking questions. So that's Rule 104. It underlies foundation. It's tied very closely to relevance. Don't cite it very often, but it's good to know and understand, especially in your back pocket as responses to relevance objections. Hope that made sense. I'll see you next video.